evening, Inglewood. Please be seated. Just want to start this evening by welcoming everyone to the Inglewood Municipal Court for our hopefully biannual State of the Court presentation. It gives me real pride and hope for our community to see so many people gathered to hear about our court, the community court. I hope that many of you truly feel this way or will feel more this way after learning more this evening. We've historically enjoyed a court here in Inglewood that we can all be very proud of. I'm Joe Jefferson. I'm our presiding municipal judge. I love our community. I'm proud to serve, and I'm proud to call Inglewood home. I want to thank all of you, the community stakeholders in the room and online, for setting aside time to become more educated, engaged, empowered residents, judges, attorneys, service providers, public servants, and leaders. Tonight, I'm going to try to provide some insights into the court's achievements and challenges, specifically over the last 2 years since our inaugural presentation in 2023. Before I launch into this a little bit, could I get a show of hands of who's actually viewed that presentation from 2023? I knew many of you were present in the room back then. Okay, looks like a majority of folks, but so that's a lot. I'm going to try to do an abbreviated overview of our unique organizational structure here in Inglewood as it relates to our local criminal justice system, as well as provide an abbreviated overview of our court operations and recent changes, including highlights of our ever-evolving and celebrated community problem-solving programs, including our Community Justice Services program, our Court Navigator program, and our Restorative Justice programs. Our elected judge has the unique challenge of being a full-time judge as well as overseeing a major branch of our local government. It's been a dynamic and challenging time for courts and our community, so I think it's critically important that we keep the community informed about recent changes and provide more public information about what we do and why we do it. I want to introduce everyone to our amazing court administrator, Kenitha Julian, who helped make all this possible this evening. She is our fearless administrative leader and keeps us all on track around here. In fact, she was recently elected to serve as a board member of the Colorado Court Administrators Administration here in Inglewood, here in Colorado, and also presented at the recent CML annual conference. She's becoming a true subject matter expert, and I couldn't do my job without her. Thank you, KJ. I will also want to introduce you all to some of our associate judges who serve our community by being recommended by our presiding judge and then appointed by our city council to a 4-year term. In attendance tonight, we have some judges currently serving 4-year terms, including Judge Dave Spracacci. Give a wave, Dave. As well as Claire Lee Carlton. Jonathan Lucero had to run, I believe, but he was present here a little bit earlier. Jonathan also had previously served as an associate judge here before being stolen away as our prosecutor, before being appointed as the presiding judge in Wheat Ridge, as well as now in Lone Tree. So we're all very proud of Jonathan and his accomplishments. We're also really happy to have an older, longtime judge, Judge Linda Cohn, who left us after decades of service to enjoy her retirement with her celebrity husband, Doug Cohn. Are you guys back there? Also, we're lucky to have Judge Benfiga with us tonight, who also served as associate judge for a couple of years before being stolen by our governor for appointment to the district court in the 18th Judicial District, now only covering Arapahoe County. It's an honor to have Judge Figa here. Judge Figa, give a wave. I also want to thank our other elected officials as well as city officials for attending. I know that we have longtime city council member as well as former Mayor Pro Tem Rita Russell. Thank you for being here, Rita. We also have council member Kim Wright. Thank you for being here tonight, Kim. As well as council member Tina Prang. Thank you for being here, Tina. Tina is also our former school board president. Thank you for your service to Inglewood. We also have our city manager, Sean Lewis, present. Thank you for being here, Sean. A couple directors, including Victor Rochelle, as well as our Chief of Police, Dave Jackson. Thank you for being here, Chief. Thank you again, everyone, for being here and for all of your service to our community. Finally, before I get into the meat of the presentation tonight, I want to take a moment of personal privilege, if you guys don't mind. I want to recognize my mother, who's present tonight. Mom owned and operated a business here for over 47 years in Inglewood, and it's only with her countless sacrifices that I am the man I am today and that I'm able to do this tonight. That is why I do this job. In fact, to return the favor to a community that welcomed an immigrant outsider and her kid and allowed an opportunity for us to live the American dream here in Inglewood on South Broadway. Thank you, Mom. I also wanted to thank my dad, who at least some of you in the room may still recall. He and my mom split when I was young, and he left Inglewood in the 90s. But it's his Southern hospitality that taught me that there's a right way and a wrong way to go about doing anything. And that's how I describe the ideals of what we call procedural justice and the 4 pillars of voice, neutrality, respect, and trustworthiness that is at the heart of our court's mission. I hope you see those values shine through tonight in our presentation. Thank you, Dad. Okay, on with the show. Thank you for tolerating those moments of personal privilege. Let's move on to talking a little bit about the separation of powers here in Inglewood. Our court was established by charter in 1959 when the city exercised home rule authority to establish a municipal court well before many of our peers. Hopefully everyone is aware of the separation of powers doctrine as modeled by the U.S. and Colorado constitutions that creates a system of checks and balances by separating the 3 branches of government. Our founders in Inglewood, in my humble opinion, were wise to separate powers of our local government in our initial charter. This means, for example, that local police matters of enforcement are executive, which is mostly vested with our city manager here tonight. However, some remains with our mayor, including the ability to unilaterally appoint some positions, as well as to fully pardon anyone of any violation of our local laws. Creating local laws and city policy are, of course, a legislative function, and that is controlled by our 7 elected officials on council. Municipal court matters, however, are judicial and fall under the authority of our elected judge to interpret and apply our local laws to individual cases. Our unique government structure has many benefits, including true separation of powers that I believe substantially increases public trust in our local court. We are a criminal court, although we do hear decriminalized traffic and parking cases too. Our court sits between the city government, who represents the people of Colorado in our cases, and a private individual to try to provide a fair and public process to efficiently and effectively resolve the conflict while preserving public safety, and if appropriate, proceed to suitable sentencing and/or probation. In each of our cases, the city is represented by a prosecutor, Arnie Shunnison, who I believe is present tonight. Arnie, give a wave. Thank you for being here tonight. Our court has exclusive jurisdiction over matters that are alleged violations of our local laws only, and what might be thought of as concurrent jurisdiction in Inglewood with our state court system. However, they are different bodies of law. Municipal ordinance violations filed here versus state statute violations filed in county or district courts. Municipal offenses are their own category under the law and are not technically felonies, misdemeanors, nor petty offenses. However, our cases would be the state equivalent of misdemeanors at the high end, all the way down to offenses with no state equivalent in the state system. Therefore, our community members are exponentially more likely to have interactions with the municipal court than any other type of court. That means that we have a unique opportunity here in Inglewood to make a lasting impression on our community, to increase public trust in local government, reduce recidivism, to increase public safety for all, and to ensure public trust in our judicial system. The good news is that criminal justice is a team sport. and all of us in this room in our unique roles share a collective responsibility for securing liberty and justice for all here in Inglewood. As our state Supreme Court said in a letter to all judicial officers, the rule of law on which our nation, and I'll add our city, are founded are sustained only by society's collective belief in it and our collective responsibility to uphold it. And that means that local laws must honor the community agreement to do justice to each other and reflect the community they serve to ensure legitimacy and basic rights. This means that the judge must be able to make decisions guided by the law, free from undue influence or personal attacks. This means that we all must be active participants in our community to honor our civic duty to our neighbors, to ensure our government always serves the people. As Alexander Hamilton famously said, I believe it was Federalist 51, if men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. So why do we have an elected judge in Inglewood? I'd like to read from a historic document in old court records that of course is hearsay that I cannot, with 100% certainty say is true or untrue, but I think it illustrates why some communities may prefer an elected judge. So I've redacted the names to protect the innocent, but in the 1950s, prior to our charter, we had a police magistrate who was fired because, quote, the chief of police didn't like his ruling in a case involving a homosexual act, which the magistrate dismissed because there was no ordinance prohibiting such acts. During the time when the Charter Convention was being held, there were only a few of the 21 elected Charter Commission members that supported an elected judge until this incident. A case came before the next police magistrate, where a young man had been left in charge of his house while his parents were away. He invited 4 or 5 kids over, and the party was crashed by a large group of South High students who left beer cans, etc. Defendant tried to keep them out, but they forced their way in. Neighbors called the police. By the time the officers had arrived, all the kids left, and there was only this young man. He was charged with a disturbance. After hearing the case, the magistrate was convinced that the defendant had not caused the disturbance and found him not guilty. The chief of police was very upset and came to the magistrate's office and wanted him to explain why this happened and stated that he would have him fired. The magistrate threatened him with contempt of court, and the chief went to the newspaper. The Judicial Committee of the Charter Convention recommended an elected judge and convinced the other charter members that our court needs to be independent, and they agreed. And it says the chief was investigated for interference with the court. This is a great example, even if fiction, which I doubt given the names in the document, of why courts need to be independent and be able to check government actions carried out by people. I truly believe in our ability to govern ourselves here in Inglewood, but with great power comes great responsibility. Our court's simple mission is to ensure justice with dignity for all. Our court must ensure a fair and impartial system to resolve disputes without resorting to violence. This process ensures accountability for all parties, including the court itself. We must give respect to all who appear. We must understand that trust is earned. We welcome all who appear. As many have said, our community as a whole has been recently reminded that confidence in our justice system is fragile and not universal, and cannot be taken for granted. The court must protect the rights of all people, not just some favorites. One of our court's other primary functions is to deter and punish crimes where appropriate. This, of course, helps create and define and enforce social norms through a legal public process. Jail is sometimes an appropriate sanction in our cases for the dangerous or egregious situations after considering all alternatives. However, our court also has rehabilitative and restorative functions. Our goal is not just to punish an offense, but also to refocus an individual on education, personal responsibility, rehabilitation, and ultimately restoration of the community as a whole. Our court has a shared mission with many local and regional agencies and have recently cultivated great partnerships for services. This reflects our newer, more community-based approach that creates more win-win situations. These partnerships help remove the financial hurdles to the education, mental health counseling, substance abuse treatment, and other services and resources needed for successful rehabilitation. This includes our community service in lieu of fines and costs for defendants who are determined to be indigent by our court. Our great partnerships and community work have provided meaningful community service opportunities in lieu of simply a waiver due to inability to pay. These opportunities provide defendants both an opportunity to make right for a wrong in our community through public service, as well as an opportunity to get services and resources themselves, all at no cost to them or the court. This is all in an effort to ultimately protect public safety for everyone in our community. These functions require time, effort, and care to try to understand the underlying issues with a person's behavior, to try to inject right-sized personal responsibility while problem solving on behalf of the community. This chart breaks down the cases we've handled over the last 5 years. Criminal contains a mix of criminal charges, including crimes against a person like assault or harassment, crimes against public peace and safety like disorderly conduct or false reports, property crimes like theft and trespass, business license and tax offenses, animal offenses like dangerous behavior or animal at large, offenses involving minors like wrongs to children or charges against juveniles, real property code violations like snow removal or zoning violations. As you can see, quite the variety of issues being resolved by our court here at Englewood. This chart also shows the number of traffic offenses versus less serious decriminalized traffic infractions and parking cases. We are a busy court, and we handled over 6,600 city filings in 2024, and that represented an increase in filings year over year of about 64% when compared to 2023. However, this reflects a substantial increase in decriminalized traffic infractions and parking. Filings in our court are also up approximately 80% year over year and includes a substantial increase year over year of 20% on our criminal matters, as well as more serious traffic offenses of 36%. While these numbers represent a substantial increase, they still also represent a substantial decrease from where we were in 2020 and prior with criminal cases. Let's take a look at how this compares to the recently reported crime data trend from Englewood Police in their 2024 annual report. In the top chart, we see a slight increase in reported crimes in 2024 from 2023 after a small decrease the prior year. It also shows a more substantial increase in reported crimes against people like assaults and harassments, as well as an increase in crimes against society like disorderly conduct or possession of drug paraphernalia. The second chart shows total state court filings in recent years and illustrates the recent ebb and flow of case volume between the county court and municipal courts, but also shows a trend towards filing more in municipal court, as has historically been the case here in Englewood for many different reasons. We are planning on these increased filings with our court to continue through the end of the year and into 2026 for budgetary purposes. However, some new processes of enforcement like administrative nuisance abatements are on the rise in recent years here in Englewood, and that process does not require a hearing in our court. So the city has not filed as many code or animal-related cases with our court in recent years. Municipal courts have some advantages for all involved, including faster disposition, better convenience, and deeper understanding of the local community. I'll highlight that our court can and has historically played a major role in rehabilitating and restoring our community on a case-by-case basis. We can reduce recidivism and protect public safety here in Englewood by problem solving together at the local level, where we understand these issues, people, stakeholders, and the impacts our cases have on our community on a deeper level. However, sentencing can be different and has been the source of scrutiny and debate in Colorado beginning in 2023, and that has culminated in 3 cases before the Colorado Supreme Court and a rare governor veto this year, which we'll discuss in more detail later. Other challenges in recent years included unfunded state legislative mandates that I'll try to very briefly cover again today, as I covered these more in depth a couple of years ago. The first is debtor prison reform initiated by House Bill 161311. This stopped the prior process of jailing for inability to pay fines and costs and made collections more difficult beginning here in 2023. Next, we have mandatory in-custody court-appointed counsel requirements as initiated by House Bill 16-1309. This mandated that we provide a lawyer to all people that we see in custody. This is a substantial mandate that was only partially funded, and that partial funding is set to expire next year, and the city will likely need to fund this fully moving forward. Mandatory personal recognizance bonds for less than $300 property or below state misdemeanor, initiated by House Bill 19-1225 and modified through SB 21-271. These reforms have had a major impact as it took discretion away from our judge to hold a person on a municipal charge if it was a property offense of less than $50 or lower initially, but that was later changed to $300 or lower now, or on any municipal offense that is lower than a misdemeanor in a state system. So any charge that is the state equivalent of a petty offense or civil infraction or a municipal charge in which there is no state equivalent are mandatory personal recognizance when a defendant is in custody and seen by our court. Or, at the 48th hour, the sheriff also has authority to modify the bond to a personal recognizance without the court involvement. This means that if someone is given a ticket for a theft here in Englewood of $299.99 and does not come to court, the judge can issue a bench warrant and set a cash bail if appropriate to order law enforcement to take that defendant into custody. However, if the defendant cannot post that amount, when the defendant appears in front of the judge within 48 hours as required by law, they must release them regardless of how many times they failed to appear or their history. So they could have 100 cases and still get PR'd on all 100 if those amounts are lower than the misdemeanor threshold of $300. Next, we have outstanding judgment warrants initiated or modified through House Bill 21-1314. Our court cannot effect a suspension of a person's driver license for failure to pay or comply with a traffic case here in Englewood. So, for minor traffic infractions, the only real motivation to comply is to reduce points and avoid collections. However, some people are not motivated by these factors. The court can still issue a bench warrant for failure to appear to court for more serious traffic offenses, however. Next, we have automatic mandatory record sealing under SB 22099, the so-called Clean Slate Bill. This requires records not resulting in a conviction to be automatically sealed by our staff. This is a very common outcome in our court due to the outright dismissals, as well as plea agreements offered by the prosecution that end in dismissal. Next, we have 48-hour bond reform under HB 21-1280. This has required us to be able to have the ability to proceed to a virtual hearing on Sunday afternoons as of 2023 with no funding from the state. This strains staff time to meet new timelines, and if they are not seen by us within 48 hours, they will be released on personal recognizance by our sheriff. We have substantial public safety cases that are not mandatory personal recognizance bonds, like older domestic violence cases, assaults, menacing, and harassment, so we must maintain the ability to comply with Sunday hearings in order to ensure public safety here in Englewood. As of January 2024, our court lost future jurisdiction on new domestic violence filings since the city did not adopt an ordinance establishing specific protections and rights for victims, families, and witnesses of domestic violence charges, and the city now files all of these cases into our state court system. We were only one of about 5 or 6 municipalities in Colorado that handled new domestic violence cases until 2024, and our system was set up to deal with these difficult cases through our victim advocate services in our police department, as well as our probation services in our court. We continue to handle domestic violence cases until we finish the cases that have already been filed with us. Per House Bill 23-1182, all courts in Colorado are required to provide remote access to the public to observe any criminal proceeding conducted in open court. However, many have not complied due to staffing, technology, and interpretations of conflict with Colorado Supreme Court Chief Justice directives. I'm happy to announce, however, that we've resolved these issues locally, and we are now live streaming via Zoom on a link that is on our homepage. I really do appreciate the transparency to our community that this provides, and I do believe that this will increase public trust. Feel free to watch us from your couch. Next, we have House Bill 25-1276, which removes authority of municipalities to make a failure to appear a separate criminal offense that could have a separate sentence. We implemented this here in Inglewood several years ago, as we feel that sentences should always reflect the severity of the original offense. Although we can impose a failure to appear bench warrant fee and a letter fee if a defendant fails to appear, and of course we can still issue a bench warrant or default a person if a defendant fails to appear for court. In the 2025 session, we saw a couple of very interesting pieces of failed legislation that are worth highlighting here today. The first is HB 25-1276, that would have restored some of the discretion of our court to hold defendants in custody if they fail to appear multiple times. This was a Colorado Municipal League endorsed legislation, but was introduced very late in the session and needed a lot of work. This will likely be reintroduced in 2026 with more specific language. However, the big one was HB 25-1147 that created a ton of public discourse and debate before being passed by our legislature and ultimately vetoed by the governor. This was a bit of an omnibus court bill that more clearly mandated court-appointed counsel when defendants are in custody, live streaming of in-custody proceedings at minimum, and would have restricted municipal sentences to whatever the state equivalent charge would be, or if no state equivalent, they would be treated as a state petty offense, which is a 10-day maximum jail sentence and a max fine of $300. The governor in his veto letter made some very interesting comments, and I'd like to read those to everyone present. I appreciate the bill sponsors' good intentions of bringing forward policies that address transparency and the right to counsel in municipal court. However, the bill also substantially restricts a municipality's ability to react to local crime trends in ways that a local government deems most appropriate to improve public safety in their community. It is not in the interest of increasing public safety to constrain a municipality's ability to set appropriate sentences for crimes within their borders. Criminal justice and public safety issues are a shared concern among state and local lawmakers, and municipalities must have the ability to adopt laws to increase public safety based on the public safety challenges on the ground in each community. I heard from police chiefs, cities and towns, mayors, victim advocates, and business groups from around the state about the detrimental effect that this bill would have on public safety should it become law. While I oppose certain elements of the bill regarding limits on municipal sentencing, I applaud the sponsors for including provisions that clarify that a defendant in municipal court has the right to counsel. This should already be the case, but I support clarifying this right in statute. I also applaud the sponsors for working to provide more transparency in municipal court by clarifying that proceedings should be open to the public, including through online platforms. During the legislative process, the Colorado Municipal League offered amendments that would have narrowed the bill to those two topics though their amendments were rejected. I would support a bill focused on those provisions or a bill more narrowly tailored to specific crimes where penalties between the state and local criminal codes are far out of balance. I also support efforts to connect municipal defendants with resources and services to help address underlying challenges with mental health, substance abuse, and housing instability, and would support legislation efforts in this space. The far-reaching sentencing changes contemplated by HB 25-1147 could have been better examined by a successor entity to the Commission on Criminal and Juvenile Justice, with multidisciplinary stakeholders from all aspects of the criminal justice system at the table to come to a consensus recommendation on the policy. In the absence of a successor entity to the CCJJ to examine the difficult criminal justice issues with the benefits of data, research, and time, I urge the legislature to work with the many stakeholders impacted by municipal sentencing to find a more nuanced approach. This bill had very similar elements to Council Bill 17 that our city council considered nearly 1 year ago that would have capped our sentencing to the state equivalent on all criminal and all traffic matters without enumerating the specific penalty in our code. This was tabled indefinitely on second reading after passing on first reading when the council got the news that the Supreme Court agreed to hear this issue. Our court provided feedback that the penalty decision is clearly a policy decision for council to make, but that traffic administration would be very difficult due to our simplified system in municipal court and software that looks at the number of points of a traffic charge for the fine rather than the hundreds of individual charges of the state as encouraged in the instructions of the model traffic code put out by Colorado Department of Transportation. This was obviously a confusing issue for the city and the state, but regardless of how the Supreme Court rules, the community will be faced with many challenging policy decisions on criminal justice here in Inglewood in the near future. The city currently does not recommend any sentences over the state equivalent in criminal cases here in our court. Every court that has considered these issues until now, including many municipal courts and even in a recent appeal from a Longmont case, found that different sentences are an exercise of home rule authority and not an equal protections violation, nor are municipal sentences preempted by state law. Even after the Supreme Court agreed to hear these issues, the District Court in Boulder upheld a 30-day jail sentence on an appeal from Longmont Municipal Court on a state equivalent petty offense, which was a 10-day max under state statute. Our court has not made a ruling on this issue yet, as no one with the proper standing has contested the constitutionality of our ordinances or our sentences from our court on this issue to date. We hope to have a Supreme Court decision in the coming months after oral arguments in May. Many briefs were filed by the cities, Colorado Municipal League, the State Defense Bar, the Office of Alternative Defense Counsel, and the ACLU, to name a few. Public trust remains the most important, however, to courts in recent times. Trust that we're truly independent and fair and not in cahoots with the prosecutor or the defendant in a case. Trust that we are a legitimate source of authority. Trust that we understand implicit bias in human behavior. Trust that we understand the value of a community-based approach to local problem solving. Trust that we protect public safety. Those are difficult issues that require a nuanced and knowledgeable approach to each case that comes before us. However, public trust is paramount to public safety. This affects not only compliance with court orders, but also general compliance with the law. I believe we've done an excellent job of maintaining public trust here in our court through an unprecedented time. Defendants experiencing homelessness has also been on the rise for several years. The overwhelming majority of people who fail to appear at our court and remain in custody in our court are indigent, and this creates unique challenges to compliance with court orders and the law. The community survey of 2024 showed that roughly 8 in 10 residents of the city of Inglewood felt that Inglewood should do more to address the problems associated with homelessness in the community. Our problem-solving programs are tailored to address the root causes of homelessness on an individualized and cost-effective basis through our partnerships with local agencies. In 2024, fewer residents felt safe from violent crime compared to 2022. I'm not sure that these are related, but having more people in our community in crisis is not ideal. We must improve our ability to not ignore criminal activity in our community, but also not ignore human suffering and the underlying behavioral health challenges in our community to protect public safety for all here. Cost of our operations have included substantial cost increases due to general inflation in the market, but also with the city's Class and Comp initiative that increased court employee compensation by over 10% for 2 consecutive years. While this is really wonderful news from an employee retention, job satisfaction, and a training perspective, the cost of people is by far our largest expense as an operation and puts pressure on the court budget to try to do more with less. Technology continues to be a source of both innovation and increased service levels, but also a source of frustration and requires expertise that has not been traditionally required by our court staff. We finalized the implementation of our newer case management software, featuring a new payment portal for the public to be able to pay online, as well as hopefully be able to view the upcoming docket or your upcoming court date in the near future. Statewide criminal reporting and warrant bond management between jurisdictions has also been challenging for us in recent years, particularly post-COVID. However, this has substantially improved in the last couple years. There's been discussions on the statewide level for a better system for municipal offense reporting, but with the state finance struggles, that really seems far away. Further, our communications with sheriffs statewide have substantially improved after meeting with the sheriffs and undersheriffs at their conference. As the president of the Colorado Municipal Judges Association, I presented along with several of my presiding judge colleagues from Aurora, Boulder, Lakewood, and Westminster, and that has led to better policies and procedures statewide. However, this includes our staff being much more responsive to issues statewide to evaluate virtual options and ensure completely accurate records statewide. Our team is up for these challenges. Our court staff is small but mighty. We've already introduced our other judges in court administration that oversees, and our administrator who oversees a total of 9 positions. However, our deputy court administrator, Evan Venrick, has been an outstanding addition, and he oversees a team of 5 specialists now that focus on the day-to-day operations of cases that impact people's liberty and due process rights, and is extremely important work. We reduced our FTEs by 1 full-time specialist in 2025 as a cost saver due to case volume decreases and technology efficiencies. We are holding open the lead specialist position as a cost saver until the additional labor is absolutely necessary, which we do not anticipate until next year at the earliest. We are also holding open our court navigator position until we reevaluate some new community resources and some restructuring we're working on internally, but we've agreed to downsize that position to a 32-hour full-time role as another cost saver in 2026. I also want to highlight our recent changes to our 3 programs. In an effort to reach our goals, particularly with rehabilitation and restoration and community collaboration, we've implemented 3 wonderful programs that we want to highlight tonight. I view all of these programs as extensions of the court itself and functions that fit the mission with great flexibility to meet our community needs. These programs transform the entire court in what is possible and alleviates the necessity of individualized specialty courts, since they are agile enough to individualize services based on the unique circumstances in a very efficient way, in my humble opinion. First is our continuing restructuring of what we now call our community justice services under Christy Mestis' leadership. Christy has helped us to combine our formal supervised probation function with a new process for unsupervised probation that has allowed additional monitoring and support for compliance prior to a scheduled hearing that has reduced mandatory appearances in our court. These reduced appearances also reduce costs, as it lowers the burden on our specialist and for our city prosecutor. She meets with the defendants one-on-one after sentencing to ensure understanding of all requirements and answer questions, and also provides an additional contact for early compliance and notifies our prosecutor. We have also expanded our ability to fund pretrial services, now including competency determinations and probation-funded services in recent years. Although limited, this is all under Christy's management and can include monitored sobriety, educational classes, or behavioral health services. She also makes payment reminders and has increased successful completion of clients with court orders. She's also filling in as our court navigator temporarily, so she's wearing many hats here. Recent successes of the program, including heartwarming thank you letters, particularly from a client in our court recently who faced substantial challenges, but was able to work through those with some of the help of the navigation program. We've also had a lot of success assisting multiple clients to secure a bed at Landmark Recovery, in fact, with a ride recently provided from court within hours of the initial request. We also hope to help be able to coordinate transitions of those clients from the initial intensive inpatient to places like the new Bridge House here in Inglewood, or the Ready to Work facility, or other sober living places and other sober living facilities. Next is our Court Navigator program. This program is a voluntary engagement for now, but may evolve to a more formalized diversion program in the future. The Court Navigator's goal is to improve community and individual outcomes through increased voluntary cooperation. This helps clients achieve their goals, including their court obligations, and partners with existing local agencies to provide resources for rehabilitation. This program is an asset to the community by enhancing public trust in our local justice system, increasing public safety, and saving money for taxpayers. Although this position is recently vacant, I'm excited to announce that we received a Justice Assistance Grant from the Department of Justice for our excellent work with both the court navigation and restorative justice programs. We will have a part-time temporary grant-funded position coming in to fill this role here soon to evaluate how to move forward with the newer changing landscape of resources, including the Bridge House facilities that I just talked about, the Ready to Work facility, and the Navigation Center. This program has now served hundreds in our community, and we're working on better ways to report more detailed data on the program through its multiple renditions in just a few short years. Now I'd like to introduce our Englewood Municipal Court Restorative Justice Program, led by our program manager, Ames Stinson. Ames has done amazing work to prove this model here in Englewood, and I believe we enjoy the best municipal court restorative justice program in Colorado. This program creates a win-win-win for the community, the defendant, and the victim in the case through faster disposition and deeper healing for all involved. This program improves public safety by ensuring personal responsibility, rehabilitation of the parties, and restoration of the community on a case-by-case basis. Our mission is to foster resilience through restorative and collaborative community and system responses to crime and conflict. In a facilitated conversation between the responsible party, harmed party, and community, a contract is agreed upon by all to repair the harm created by the offense. In our program, we use a community group conferencing model, and the responsible party must successfully complete the requirements of the contract within the deadline and not reoffend in any way in order to successfully complete the case or be subject to traditional prosecution in our court. In our court, this amounts to a diversionary opportunity for appropriate cases after a criminal justice filing with our court. Eligibility to participate in the program includes harmed party consent. Without their consent, the case will not go through the program. Responsible party accountability. If the responsible party does not take immediate personal responsibility for their actions, the case cannot proceed to restorative justice program. This program currently handles the overwhelming majority of our juvenile case docket, maybe upwards of 95%, and we're now handling more adult cases as long as not domestic violence or traffic only, and no one with an active bench warrant. Finally, the city prosecutor must approve, and the judge must also approve. In Colorado, data shows great success. Research also indicates that utilizing restorative justice can disrupt the school-to-prison pipeline as well as interrupt cyclical involvement in the criminal justice system. Our 2024 report showed very similar results here in Englewood since our first full year of the program in 2022 that we're very proud of. This program has been very successful, and the data proves that. The hard work of the community has been fruitful, as evidenced by our recent grant funding, as well as our intergovernmental agreement with the City of Littleton. The intergovernmental agreement is to share services and costs of the program. The final IGA is pending second reading with our City Council and has already been approved by Littleton. They can send a few cases a month and help us with the cost of the program to ensure ideal caseload and efficiencies as we expand the capacity of the program with more volunteers. We now have over 60 trained volunteers, as well as over 10, I think it's somewhere maybe around a dozen, certified to lead groups ready to help our community. Please get involved. Join us for an upcoming informational session to learn more about the Englewood Municipal Court Restorative Justice Program and how to become a program volunteer. The Justice Assistance Grant from the Department of Justice I mentioned before is in addition to our RTD grants. The JAG grant from DOJ includes 2 part-time temporary grant-funded positions, one for restorative justice that is currently filled, and I think she's actually present here tonight. You still present? Give a wave. And the second is going to be for the court nav and is going to be filled very soon. It also includes funding for technology, resources, and a survey to help direct future efforts. We're very proud that our hard work and vision is recognized by others. We also received a second-year grant of bus passes from RTD that are very helpful in court appearances, appointments with service providers, and compliance with court orders. Thank you all for being part of the same community that I'm really proud to call home. Our people and our relationships are what define us as a small town here in the big city. Your combined engagement and contributions to our community as elected officials, city leadership, judges, attorneys, court staff, a resident, or business or service provider, or just friend, are really what I think makes Inglewood so great. Our court has engaged Inglewood's core values through our efforts to make Inglewood safer and the best place to live and do business. Thank you all for the opportunity to share. God bless you all, and God bless Inglewood Municipal Court. At this time, I invite you all to join us back in the lobby for some more refreshments and networking. I'll be out there to answer questions as well. Thank you all for coming tonight.